Right?
You gonna start? Good morning, everybody, and welcome to the Leaders Walk this morning. In this wonderful summer weather that we are having, I'm going to hand over to Malcolm. He's going to take you through the session this morning. Please, if you've got any questions, put them in the chat box, and I'll be actually interrupting Malcolm throughout the session just to ask him your questions. So please do put your questions in the chat box and we'll try and get through as many as we can. Malcolm, over to you.
Okay, thank you. And I'm going to resist the temptation to say that as Colleen is my wife, she's very good at interrupting me. So no, I'm not going to say that. Okay, welcome everybody. Thank you for joining us this morning. We are going to look today at reading legislation. Now, yeah, it's a case of, why should we be bothered about legislation? Is legislation not for attorneys and for legal departments? And I'm going to show you this morning that no, that is not the case. And by the time you have finished this Leaders Walk this morning, hopefully you will be able to read legislation easily and quickly to your benefit. And there's a huge benefit to being able to read legislation. So this is actually part of a session that we do for the board masterclass series that Business Engage runs. And I see one of the other presenters, Patrice, is with us today. Welcome, Patrice. So yeah, it's a session that we do for the board masterclass series. And I think you can think about it as everybody has heard of all of the courses about finance for non-financial managers or for non-accountants. You can think of this as reading legislation for non-attorneys, people without a legal background. And it's really about how to bulletproof yourself in today's environment. Now, before we start, just a disclaimer, this is not legal advice. I am not an attorney. I'm actually a quant surveyor by profession. That's what I did in a previous life for about 30 odd years. So this is all a practical point of view based on my experience, my many years of experience. You can see my grey hair. So yeah, that's the angle that we are coming from this morning. We're not going to get into issues about maritime law and all of the issues of contracts. So that's that's an all-day session talking about that. So we're not going to get involved in that. As Cole says, if you've got any questions or comments as we go along, please put them in the chat and we will try to answer them. We're going to split this morning's Leaders Walk into, we're going to look at legislation that will affect you personally, and we will look at legislation that may affect you from a professional point of view. We're not going to delve too much in the professional point of view because obviously it depends on what profession, what area you are involved in. So that is going to be more in the second half of this morning's Leaders Walk. And we're also going to split it into basically 3 sections. The first section is I'm just going to chat to you about legislation and various legislation and give you examples of legislation. And then the second part, I'm actually going to do a bit of a slideshow to show you how legislation is broken up and how you then read the legislation, how you can quickly read the legislation, and then we will end up with a question and answer session for anything that hasn't been covered, at the time. So let's just kick off looking at it from a personal point of view. And the first thing that we need to ask ourselves a question: well, why be bothered? So why do you want to read legislation? Why do you want to know about legislation? Is that not for the attorneys? Is that not for the legal department? And the answer to that, very simply, is no, it's not. There can be a cost to you not knowing legislation. There can be a financial cost to you. And I'm going to give you examples of that as we go along. So not knowing legislation can hurt your pocket. Conversely, it can save you a lot of money. And I think in today's environment, anything that we can keep in our pocket, the better. There can also be a physical or an emotional cost to you. And again, I'll delve on that very, very quickly as we go along. And when you're looking at it from a professional point of view, there could also be a professional cost to you as well. So that is why I say that you need to know legislation. But I also accept that, as I say, I'm a quantity surveyor by profession, dealing with contracts and legislation. That was very, very much part of what I did, what my job was. But I also understand that is not for everybody. If you're more of a marketing person, if you're more of a soft skills person, etc., then maybe the last thing that you ever want to do is to read legislation. It's just not what you do. So hopefully by the end of this morning, if you do want to read legislation, you can do it, and you can do it quickly and easily. So with that introduction, let's start looking at a couple of examples of legislation. And I'm going to start off with the National Credit Act. Anybody who has a debt really should know the National Credit Act, especially if you get into a situation where, sorry, I'm getting feedback here. Especially if you get into a situation where you are falling behind on your payments and life is getting financially difficult, which happens to us, all of us, at the best of times. 1 minute things are you're doing really, really well, and the next minute, for whatever reason, a lot of the time it's out of your control. Finances gets difficult. Let's say that you're in a situation where so both yourself and your spouse work, and you have to work because you've got to pay the bond, you've got to pay for the kids' education, etc., etc. One of you now gets retrenched, or a business that you are involved in isn't going as well as it should be, and finances get difficult, and you start falling behind on your payments for your car, your bond, your credit card, etc., etc. Well, in that case, you really need to know Section 129 of the National Credit Act, which says that if you are falling behind in your payments, the credit provider has to bring that to your attention and allow you to make a plan, and I'm paraphrasing here, and allow you to make a plan to bring those payments up to date. And before they allow you to do, so until they've allowed you to do that, or they've advised you to go to an ombudsman or an alternate dispute resolution agent, or sort out any disputes that you may have, Before they have done that, they may not take any legal action against you. So they cannot say, okay, Malcolm, you owe me 50,000 Rand. I am issuing summons against you in a court of law for the recovery of that money. If that happens and they haven't complied with Section 129 and has allowed us a time to try and resolve it, then the courts will not hear that matter. And the whole point of this is they want to stop people running to the courts, overburdening the courts and saying, look, you must make more efforts to try and sort these issues out prior to taking legal action, and stop just using the courts to sort it out. So that's the reason why it is there. From a financial point of view, from a cost point of view, I, over many years, have saved people having their cars repossessed, having their houses repossessed, just by advising them in terms of this clause, in the National Credit Act, on numerous occasions. A debt collector will knock on somebody's door and say, you are in arrears, for the financing on this car. We have come to repossess the car. Now, if you don't know any different, then you are going to hand over the keys to the car to the debt collector. And I know from experience, you try getting that car back, even if they haven't complied with the Section 129, it's this thing of possession is 9/10 of the law. Well, in actual fact, it's not. It's 10/10 of the law. You're not going to get that car back. So the issue is, don't give them the car in the first place until they have gone through all of the the proper procedures with regards to you trying to make a plan. And then if you've got to hand over the car, then at that point you can certainly do that. I remember many years, a number of years ago, our daughter bought her first car and she was so excited, brand new car. And I went with her to Colin. I went with her to the dealers, and she bought the car and she signed all of the documentation. And the lady that she was dealing with went through everything, explained everything to her. Everything was going great until the lady turned around and said, oh, by the way, if you don't make the first payment, we are going to come and repossess the car. And I said to the lady, would you like to say that again, please? And she says, if you don't make the first payment, we are going to repossess the car. I says, now would you like to tell Jade about the National Credit Act and what you actually really are going to do if she doesn't make the first payment? The lady went out, spoke to a manager, came back in and said, no, well, in actual fact, what we're going to do, if you don't make the first payment, then we're going to issue a notice in terms of Section 129 of the National Credit Act. I says, thank you, because that is what you are going to do. You are not going to come and just take the car because you just feel like taking the car. So that was on a car. Just recently, fairly recently, I stopped a gentleman having his house repossessed. The gentleman is an artist, a wildlife artist, apparently very, very good one. He's got about 3.5 million rands worth of art that he couldn't sell because of the 2 years that we've just had of lockdown. So his business, his income as being an artist was just totally decimated. So he got into arrears of 90,000 Rand on his bond. He had been paying the bond for about 10 months prior for him talking to me about it. And let's say that he had to pay 15,000 a month. He was paying 17,000 a month. So he was paying his bond, he was paying 2,000 extra that he could afford, and he'd been paying it for 10 months. What he couldn't afford was the 90,000 rand in arrears that had accumulated whilst he was earning no income due to the lockdown. Again, he got a letter from the attorneys, which was wrong in terms of Section 129 of the National Credit Act. And again, yeah, so like talking this morning, I'm not taking a stab at anybody, not financial institutions, not attorneys, nobody. This is just based on experience. But attorneys often get it wrong. Don't think that you've just got a letter from an attorney that they've got it right. Because a lot of the time they know that what they're doing is not right. But they also work on the basis that you don't know any different. So they try and get away with it for their own benefit and for the benefit of their client. So anyway, so these attorneys wrote this letter, demanding the 90,000. And we went back to them and says, look, you haven't complied with Section 129. You cannot take this matter any further. So we don't really care what you are saying. But we also acknowledge that 90,000 has to be dealt with. You know, if you borrow money, you have to pay it back. It's quite simple. But what I suggested to this gentleman was he goes back to the bank and asks them if they can amortize the 90,000 rand over the life of the bond. So he did that. They agreed to it. He could afford to do it. So, because he was already paying 2,000 rand more than he was due to pay anyway. The bank's no worse off because they're getting all of that additional interest on the 90,000 over the life of the bond. I says, get them to agree that, then as soon as you can, pay the 90,000 rand off so you're not paying interest on it. And the bank agreed to it. So now the gentleman was happy. His house is, was secure. The bank's happy. Everybody wins. But if he didn't know about the act, or if he was told about the act, and he did nothing, and they went and took legal action against him, so he could have lost his house for no reason at all. So it's very, very important that if you've got debt, that that's the way that you've got to deal with it. And just as a matter of interest on a slightly different subject, I mentioned there about debt collectors. If you're living in a complex where you have levies, you have to pay a levy, to the complex for the upkeep of the complex, and you do not pay your levies. If you get charged interest on those levies, it's not right. And the reason it's not right, unless the whoever is collecting the levies are registered as debt collectors or attorneys, because the only people who can charge you interest on arrears are attorneys and debt collectors. So if you're in arrears and it's not a debt collector that's asking for the money, then you are not obliged to pay the interest. Of course, if you want to pay the interest, then that's up to you. You can certainly do that, but you're certainly not obliged to. Okay, so that's the National Credit Act. Hopefully everybody's still with us so far. The next one I want to look at, and this is my favourite one, is the Consumer Protection Act. The Consumer Protection Act came out in 2008, and there is a wonderful clause in there, clause 56(2), of the Consumer Protection Act that says, and again I'm paraphrasing, that if you have a product or a service that's not fit for purpose, within 6 months, if you have a problem, you can ask for your money back if it's appropriate. You can get the supplier to repair the product if it's appropriate, or you can tell them that you want it replaced, whatever the unit is. I have Colin and I have a cell phone contract with Cell-C, and many years ago, and you'll see how long ago it was, I got a Samsung Note 1. So that's how long ago it was, a Note 1. I got a Note 1 from Cell-C, and I loved the phone. It was a really good phone, but I had a problem with it. So I took it into the Cell-C store and I says, love the phone, it's great, but I've got a problem with it. This is what the problem is. And it was within the 6-month period. They turned around to me and said, okay, well, we will send it in for repairs. I says, oh, okay, and how long is that going to take? It says 3 weeks. I says, and there's no other alternatives. They said, no. I says, well, how about the Consumer Protection Act, clause 56, that says it is my choice, not your choice. It's my choice as to whether it gets replaced, repaired, or refunded. It's not your choice, it's my choice. And because you have denied me my rights, I am telling you that you're going to replace that unit. They says, no, but our company policy is you've got to do that within 7 days. You've all heard this. You've all heard stories about this. No, it's got to happen within 7 days. That's our company policy. No, well, I don't care about your company policy because the Act says it's my choice. So you will replace it. I can prove the defect is not of my doing. So you replace it. So they replaced it. It's great. A little bit later, still loved the phone. I had a problem with it again. I went back to them. We went through the same rigmarole. I says, thank you very much. You will replace it. You're denying me my rights. And on both occasions, when I went in there, I was listening to people complaining that the phones had been in for repair and it was taking too long for the phones to get back. I said, well, you shouldn't have given them the phone in the first place. So for the second time, they replaced it. Got my phone back. For a third time, still love the phone. For a third time, I had a problem with the phone. I took it back. I said, here we go through the same again, replace it. They gave me a letter saying this is the last time we are going to replace it. And they asked me to sign it. And I signed it, and I just wrote that under there, subject to the Consumer Protection Act. I can do this all day. It's not fit for purpose. It's my choice. So I want you to replace it. So again, if you have a product or a service and it's not older than 6 months and you have a problem with it, it is your right. Now, if you are quite happy that they take it in, repair it, whatever, that's fine. But it's your choice, not theirs. Okay, so that's the Consumer Protection Act. There's another clause in there, and I must admit I haven't looked at it for a long time, but there's another clause in the Consumer Protection Act about, and I'll need to look it up to remember it exactly, but it's along the lines of, if you get a service and let's say the quote for the service is 100,000 rand, and you didn't get the service that you wanted, either in terms of quality or time or whatever it is, then you can pay a fair value for that service. And basically you say, I'm paying you in terms of this section of the Act. I should be paying you 100,000. I'm going to pay you 70,000 because there are issues with with what you're provided with me. And then it's then up to them, the other party, to say, well, I don't agree. Well, go to court on it. And when you go to court, your defence is, I'm claiming in terms of whatever section it is of the Consumer Protection Act. I didn't get what I wanted, and there's not 100,000 rands worth of value, even though that is what we agreed. I've never personally done it, but it's certainly there. So that's the last 2 examples are examples where it can affect you financially, but it can also affect you physically and emotionally. I don't know who recalls about 5 years ago, 2017, about 5 years ago, the Deputy Minister of Education was involved in an altercation with two ladies in the Havana in Four Ways, and there was cell phone footage of him smacking the one lady, and there's a big to do about this gender-based violence, and everybody at the time was saying, but why isn't he being arrested? Now, I mean, he obviously, I mean, if he did what he did, then obviously, he needs to be punished for it. But the wrong question was being asked. It's not a question of why was he not arrested. The question is, why is everybody else being arrested? Because he should not have been arrested. And the reason that I'm saying that is that if you look at the Criminal Procedures Act, it actually says that, and I've actually got a copy of it here, it actually says that a peace officer, and remember, police are peace officers. They're not a cash-making machine for the local authority. They're peace officers. But it says a peace officer may, without a warrant, arrest any person who commits or attempts to commit any offence in his presence. Well, the police weren't there in this particular instance. Whom he reasonably suspects of having committed an offence referred to in Schedule 1. Well, Schedule 1 is treason, murder, etc., etc. It doesn't apply. So, my reading of the Criminal Procedures Act in that regard is there's an altercation. The lady has to be involved. You go down to the police station, lodge a complaint. And lay a charge. The prosecutor says yes, that gentleman's got a case to answer. The messenger of the court, the sheriff, goes round to the deputy minister and says the magistrate wants a word with you. You're going to go and see him next Wednesday, and you go through the whole process because he's a deputy minister. Everybody knows where he lives. So that can go through the process, and it's not a case of, everybody should be arrested for every little thing that they do. You should only really be arresting people if there is a danger to themselves, if there's a danger to other people. They're flightless, they don't know where they are. But otherwise, you can go through a normal process of, we're alleging that you have done something. You may or may not have done it, and let the court processes, the legal processes, take its course. So, this issue of being arrested, is not as simple as it should be. I drive around in my car with this document, and if anybody wants a copy of it, it's Malcolm at Business Engage. You just drop me a line and I'll actually send it to you. It's a document, and it's addressed to the National Head, Directorate of Priority Crime Investigation, all provincial commissioners, all divisional commissioners, all district commissioners, etc., etc. And it is signed on the 19th of November 2019 by the then National Commissioner, Commissioner Sitoli. And this document basically says to these commissioners, stop arresting people. And it actually says in there that a lot of the time people are getting arrested just so that the commissioner or the various station commanders can meet quotas. And it says, when you need to arrest a person, arrest him. If you don't need to arrest the person, don't arrest them. So I drive around this with my car. And if anybody wants to, threatens to arrest me, then, I mean, it's never happened. But if they want to arrest me, I'll just show them this and say, that's fine, but bear in mind, if you want to arrest me, I'm saying you shouldn't be arresting me, and you take the consequences if that happens after that. So I drive around with that in my car all the time, so they can't get arrested. But now, what happens if you do get arrested? What happens about if you get arrested? And we all know about the court procedures. You hear it all the time. Somebody goes to court and they've been given bail, or they haven't been given bail. And again, it's never happened to me. But if my kids were arrested, the first thing I would do is I'd go to the police station and say, how much is police bail? Because if you look at the Criminal Procedures Act, clause 59, the police can give you bail even before you've got to court. Why? They've arrested somebody for doing something. Again, it's something not major. It's not treason. It's not murder or anything like that. They've arrested them, but it's fairly low key. They live somewhere. They know where they live. If a police officer asks you for your address, you have to give it. And if you give a false address, then again you're liable for offence, and you can be done for it. So if it ever did happen, I'd have gone down to the police station. I'd have taken proof of my residence. I'd have taken, depending on the time or whatever, I'd have gone down to a commission of oaths, and I'd have done an affidavit to say I confirm that, let's say it's my son, I'd say I confirm that my son lives with me at this address. I'd go down to the police station. There you go. That's where he lives. If you want to take it further at a later stage, you can go through all of the processes that you need to. That's fine. But I'm posting bail. How much is bail? And if they say it's £1,000, well, there you go. There's your £1,000. Look, I'll probably say to them, look, what's he been accused of? Okay, well, let him sit in jail for another 2 hours. Let him stew a little bit first. But he's the bail. And so I would then get him out, and then you can then deal with the any issues that may come in then after that. Okay, so that's the no, bail is not an admission of guilt. Bail, you're not admitting anything. You can do an admission of guilt, but that's a different thing. Okay, Colin, sorry, before I go on to the next one, Colin, are there any that in the chat that I've missed?
No, Mel, there's just one, Fazeka, I think it is, said, Fazeka said, I wish I'd known this a year ago.
Yes, sorry, carry on.
Yeah, and then just a number of people just asking us to share the slides after when you've done with the next section.
Okay, no, that I can do. I can do with
yeah. So I've just asked everybody that wants a copy of the slides to email me, because we can't pick up the email addresses once we download the attendees register for this.
No, absolutely. If you want something, then you need to give us your details, and we'll do that with pleasure. Somebody asked about prescribed debt. Good question. Generally, debt prescribes after 3 years. No, it doesn't prescribe if you've got a judgment against you. Doesn't prescribe, because judgments, even though it is only on your credit record for, is it 5 years now? I think it's 5 years or 3 years. I can't remember. A judgment lasts for 30 years. So on year 29, they can still come to you and do what they need to. Sorry, I'll answer that just now. So they can still come after you for 30 years. Normal prescribed debt, and again, I'm going to reiterate, this is not legal advice. Please make sure that it's up to you to make sure that you know what you are doing. Prescribed debt is 3 years, but you can never have admitted the guilt, and you can never have paid it. So yeah, if I do work for somebody and they don't ask me for the money they come back to me after 4 years, they've never asked me for it, I've never admitted that I owe it, then I don't have to pay it. But you do not pay 1 cent, because the minute you pay, then prescription starts again. But generally it's 3 years. If somebody was looking for an email address, it's easy. It's malcolm@businessengage.co.za. So that's prescribed debt. I'm sorry, I'm glad you mentioned you brought that one up, because that's actually a good one and an easy one to have a look at. And then just going back to the comment, yeah.
Sorry, there is a question from Louise Ming. What if your child is arrested over the weekend for a traffic violation and the police say he can't be released until the Monday, so he needs to sit in prison for the weekend?
They will always say that. They will always say that. Then what you do is you go to any piece of legislation, you go and Google Criminal Procedures Act and you download it, and you go to the police station and you show them clause 56 or whatever it was I said, and you go to them and you say, I know what I'm entitled to, because it comes down to other people will tell you things that are wrong for whatever reason. Either they don't know, they haven't been trained properly, and I'm going to come to that just now. Either they haven't been trained properly, they don't know, or they've just got an interest or an agenda. So if it was over the weekend, and yes, they will tell you that, but you go there and I would do what I've said I'm going to do. Here's my affidavit. Here's proof of here's a copy of my ID. Here's what the story is. My son lives with me, or here's proof of, or I can confirm my son lives at wherever it is, because obviously you know where your son lives, and you're applying for police bail. And it says, yes, it may be released on bail in respect of any such offence by any police official of or above the rank of a non-commissioned officer. So if like the desk sergeant or the desk constable who was there on the desk said no, well, I want to speak to the commissioner or the the head of the station, the commissioner who runs that station. We live in Lone Hill. We fall under Douglas Police Station. I have got the head of the commissioner or whatever they call them. I've got her number on my phone. So if I went to the police station and I was told, and let's say it was Douglasdale, if it was a separate police station, different police station, it'd be different. But if it happened in Douglasdale and I went down to Douglasdale and they told me no, then I would just get my phone and I would say, there is your boss's phone number. Do I need to phone her? Because I will do. And I can do, because she's given me the number at a police community forum meeting. And she has said, please go up the rank as you need to. But if you have to phone me, you may phone me. So I would phone her and say, I want to post bail. I'm entitled to. Please authorise it. So that's how I would deal with it. But are you going to be told things that are not true? Yes, you are. We all know that's life. Okay, so that's that. Just want to go back a little bit on the financial side. The FICA Act, the Financial Intelligence Centre Act. We all know about that everybody here has got a bank account. We all know that we've got to deal with that. I'm going to look at that when we do the second part, when I actually start showing you some of the slides. Then the Poppy Act is yes, it's very relevant at the moment. The only thing that I need to know about the Poppy Act at the moment is you don't need to comply with it. People are making big songs and dance about it, but section 114 of the Poppy Act says that all processing of personal information must, within 1 year after the commencement of this section, be made to conform with the Act. Well, that was, when was it? June, July, 1st of June, 1st of July, when it came out. So anybody that's got to comply with the Poppy Act has actually got 1 year to do that. And that's normal. You get a transition. You're not used to doing something. Now you've got to do something. We're going to give you a year to get yourself sorted out. So if you need to, if it's applicable to you, that's fine. But if you get it wrong for the first year, then you don't need to worry about it. Then, before we get on to the next section, I just want to mention, I just want to bring up, another example. And I was half wondering whether to bring this one in or not, but I'm going to. We're talking about legislation, we're talking about laws. It also applies to bylaws, it also applies to regulations. It applies to anything where somebody says that you must do. Now, the comment about, oh, we should have known this a year ago, I get all of the time, all of the time. But my answer to that is, when was the best time to plant an oak tree? 300 years ago. When's the second best time to plant an oak tree? Today. You can't worry about what you didn't know a year ago, and the effect that it's had on you, either financially or you were going through a divorce or somebody got arrested or whatever it may be, but it was something that you didn't want to go through and you went through. And then at least if you know about it now, and as I say, when we get to the second part, which we're getting to fairly soon, you will be able to really get your life in control with regards to all of these issues, because if it's something that's important to you, you will start and you will know about it. All of the information's there. But the one that I was thinking about is that we just had regulations on lockdown. And again, with the lady who said, oh, we should have known this a year ago. We had the regulations on wearing masks. What a lot of people didn't bother to check was that if you were 6 or younger, you did not have to wear a mask in terms of the regulations, the lockdown regulations, the COVID regulations. How many kids did you see wearing masks who were at such a young age? And it is disgraceful, absolutely disgraceful that young kids were wearing masks. And it may have stopped them, it may or may not have stopped them getting COVID. And I say, I'm not going to get into a moral debate on this, but did it restrict their intake? Absolutely. There's right at the beginning of the lockdown, I watched a podcast of a guy who's I watched quite a bit in America, and he had 2 occupational health specialists on, and they were saying that since 1970, if you had put these masks onto your employees in your working environment, in terms of, and I'm not sure if this is countrywide or specific states, because obviously America works slightly different. So that I'm not sure about. But if they'd have caught you doing that, they would have actually stopped you. They'd have closed you down and stopped you working on the basis that the masks do not give you enough oxygen for you to work in a working environment. And that they've had the legislation since 1970. So again, when I've been telling people, so like this, and this I was doing obviously when it was still current. And again, people were saying, "Oh, we should have known that," because either they were doing it or they knew people that were doing it. And no, it's not right. Okay, so that is the first part which just goes through a couple of examples, and hopefully from that, and we can go, I can keep you here all day going through pieces of legislation where I can say, if you know about it, it can save you financially, it can save you heartache, it can save you whatever. If you don't know about it, there can be a cost to it in whatever way. And it's all about what can you do yourself. And yeah, if you can't do something yourself, at least you can then go to an attorney at the right time and say, look, yeah, this is what we need to then have a look at and try and sort out. So that's all I want to say from the first part. Cole, no questions or comments? I'm just going to put the put the screen up.
Nothing at the moment, Mel.
Okay, no, that's great. Okay, just bear with me. Just talk amongst yourselves whilst I put my screen up. Oh, it helps if you look in the right place, doesn't it? Okay, whilst I'm getting this on screen, no, actually. Why is that not coming up now? I think it's still trying to get it up. And why is this going round and round and round and round and round? Just bear with me 1 second. No, it's just going round and round and round. No, but I'm going to send it to you.
Okay.
Guys, just bear with me 1 second. It's just going round and round and round. But I'm actually just going to email it to Colin, and she can. One of us will get it open. Okay, just whilst we're waiting for that. So that's all the practical examples of so like why we should be looking at it. Now, what I said at the beginning is this may not be, if it's not something that you have a great interest in, then looking at it may be quite difficult for you. But if you look at most pieces of legislation, they all follow a very, very similar format. There you go. The question about banks is because they can, quite simply because the law allows them to. And in actual fact, yes. So like what's called it's disappeared again. Whilst we're actually waiting for Cole to put that on the screen, that banks can do that. The chat was, if you didn't see it, why can they auction at? You've almost paid up for your house, and then they auction it, and they can auction it for nothing. They can actually auction it for 10 rand. At least they used to be able to. I think that may have changed now. But they used to be able to do for 10 rand. But if I encourage you all to join, what is it, DSA or Dear South Africa, where they come up with all of the bills and say, this is the legislation that's going through. You know, we vote for the government. The government, you know, gives us the legislation, and you know, if we're not happy with it, well, you know, we must do something about it at the time. If you look at the ARTO Act, ARTO, in my opinion and many other people's position, is not about saving lives. It's about income generation. That's all it is. They also initially deny you your right to be presumed innocent, which is somebody's going to make a constitutional challenge with regards to that. Polly, you get it? You coming right?
I had it sharing, so let me just try again.
I know you did. You had to share it twice, and then it went off twice. There you go.
You got it?
Yeah. Okay. Okay. Can everybody see that? Give us a thumbs up or a shout or a. I can see it. Will somebody just tell us that they can see it? Give us a thumbs up or a.
I've got it on mine.
I can see.
You can say okay, and instance you can see. Yes. Okay. Okay. That's right. Okay. Fantastic. Thank you. Right. All you need to know about reading legislation is that the index is everything. The index will tell you exactly what you need to know. Carl, please put the next slide on. Can you put it into normal viewing?
Every single time I change it, it actually goes off. Let me try.
I can still see it.
Just let me see now. Okay, can you see it?
Yeah, okay, that's fine. Try and move the next slide on. There you go. There you go. That's great. Okay. Any piece of legislation, yes, like you'll have the Gazette, and obviously, like any other document, it will have an index. If I want to read a piece of legislation right from the beginning, and this applies to not only South African legislation, you can look at British legislation. At the one of the last board masterclass series that I did on this, one of the ladies asked me to look at legislation in Scotland, and yes, well, again, it's very, very, very similar, but legislation will have the main body of the legislation. A lot of them will have stuff about commissioners, ombuds, regulators, tribunals. CIPIC, yeah, your companies has a commissioner. Poppy has a regulator. The National Consumer Act, they've got commissioners. The National Credit Act has got regulators. Sorry, regulators, not commissioners. Has got regulators. The Consumer Protection Act has got tribunals. The Companies Act has got tribunals. So there's a whole section on commissioners, ombudsmen, this, that, and the other. There's always a big section about enforcement and offences. There's always stuff that is part of the main body that is time sensitive, and I'll come back to that just now. And then you always get general provisions and definitions. Now that generally is the layout of the majority of legislation. There are exceptions. The Income Tax Act of 1962 doesn't follow this at all, and I find it quite difficult to read that one. But that's an exception to the rule. Most of them follow this kind of format. So if I'm looking at legislation, will I read something based on the index, not reading through it, but based on the index, will I read something? Now, if it's in the main body, well, it depends, because I'll actually go through each heading and I'll say, yes, and I'll give you, we're going to go through examples just now. But I will go through and say, yes, I'll read that bit. No, I won't read that. Yes, I'll read that. No, I won't. So it depends on what it says. Will I read about commissioners and regulators? No, I won't. Why? Because it's got nothing to do with me. There is no value to me of knowing how the minister appoints the commissioner, how the commissioner appoints their staff, how long their period of tenure is. What they're entitled to do, what they're not entitled to do, how the tribunals work. I don't care. It's got nothing to do with me, so I won't read it. Enforcement and offences. No, I won't read it unless I think I'm actually going to be guilty of an offence, and then I may want to know about it. But otherwise, no. I don't care what you've read in the main body that if you don't do something, you're guilty of an offence. Okay, I get that. Well, I won't do it. But I'm not bothered about how it gets enforced or what the offence would be if I'm not going to offend. If I'm going to offend, then I may want to say, okay, well, it may cost me 300 rand in fine, or I may go to jail for 10 years. But I think generally you would tend to know that anyway. Then something, if it's time sensitive. Let me give you an example. If I am reading the Companies Act and business is going well, then I will not read about winding up businesses because it's not appropriate at this moment in time. If I've got a business and I have already incorporated that company, I will not read about incorporating a company because it's not relevant. So if it's time sensitive and it's not applicable, then I won't read it. I will just know that it's there. So I know that the Companies Act has got a provision for winding up. I know that the Companies Act has got provision for business rescue. But unless I'm so in that position where I need it, no, I won't read it. And then general provisions and definitions, then I will glance at them. General provisions, they're generally nothing of interest, but there might be. And if there's something of interest, I will look at it. Definitions, I will glance over because maybe there's a definition in the Act that I don't know. So I will just glance through and say, look, yes, okay, I understand all of that. That's all fairly easy. Or when I'm looking at the main body, there'll be a definition and I'm thinking, what do they actually mean by that? And then I'll go to the definitions and see if it's in the definition. But otherwise, I'll just generally glance over it. Carl, next slide.
Sorry, it's not moving, Mel.
This is a pain, this.
Let me just... That...
I'd just like to show at least 3 slides if I can. If we can't, I'm just going to tell you about them.
Yeah, I'm just going to share my screen again. Hopefully it will pick it up again.
Okay. Well, look, let's try. But no, there you go. There you go. Okay. No, that's great. Look, we don't have too many slides, so yeah, it's not a major problem. Okay. So let's go back to the Criminal Procedures Act that we mentioned just now. It's 221 pages in total. Have I read all 221 pages? No, I haven't. Do I intend to at the moment? No, I don't. I've read about arrest, so I know about arrest. I've read about police bail, so I know about police bail. Have I read about all the different pleas? No, I haven't. Am I going to? No, because it's time sensitive. I haven't been arrested. So I haven't. I'm not in a situation where I've got to go to court or somebody that I know and love is in that position and I want to give them advice. So it's time sensitive. It's not. I don't need to know about pleas. I don't need to know about witnesses. I don't need to know about sentences or whatever. All I need to know on the Criminal Procedures Act at the moment is arrest and police bail. and that's it. The rest, I know it's, you know, it's in there somewhere, and if I need it at any point in time, then I'll go and have a look at it. Okay, Cole, try and get the next one on.
I have to go out of.
Yeah, no, okay. Look, as I say, there's not that many slides, so it's not that big a problem. Okay, I mentioned briefly the FICA Act, and I said we'd deal with it now. Again, it's 28 pages long. It's 82 clauses, and I'm going to give you 3 stories related to this. There is, of those 82 clauses, there are only 6 clauses that you 6 or 7 clauses that you need to know about. The banks, or sorry, the financial institution, the accountable institution, needs to be able to identify who the clients are. They need to understand the business relationship. In other words, how are you getting your money? What do you do? Yes, what's your modus operandi for your business or your personal income? Additional due diligence for legal persons, trust and partnerships, as opposed to an individual. The inability to conduct the due diligence. Cash transactions above certain limits. So I want to know that, okay, if I put in 100,000 rand cash in the bank, I know that bank is going to report, is going to send it on to the centre. Do I care about it or not? I didn't get the money from the Guptas, so I'm fine. I don't care. If I do care and it's 100,000, then I'll put in 90,000, because there's no obligation then for the institution to let the centre know. And electronic transfers to and from the Republic. Okay, so what do I need to know that? That is all I need to know in terms of the FICA Act. Everything else goes back to what I was saying previously, that it's all about the running the intelligence centre. It's all about what the accountable institutions have to do, what they have to report, and how they have to do things. Now, I don't work at Nedbank, I don't work at Standard Bank, so I don't care about that. That's not my job in life. So I don't need to know that. So all I need to know is that this is what I've got to do, I've got to know about in terms of FICA. Then in terms of definitions, there's 2 definitions there that I was like, yes, I need to know this. So it's, what is an accountable institution? And it says, the accountable institution is what is detailed in Schedule 1. What's detailed in Schedule 1? Well, it's your financial institutions, it's your banks, it's your insurance companies, it's your stockbrokers, it's anybody that you deal with on a regular basis to do with money. That generally is it. What is a business relationship? Well, you and I understand a business relationship differently. In this case, it's a business relationship with a client, customer, me, and an accountable institution. If you are not an accountable institution in terms of the FICA Act, there is no business relationship in terms of the Act. Now, let me give you 3 stories about FICA. First one, when FICA first came out, Colin and I got an SMS from our business bank saying, you have not complied with the FICA Act, and if you don't comply within a certain time, we reserve the right to freeze your account. And I know that one of the banks, there was major problems with them freezing accounts at that particular moment in time. Colin and I got in a car, we went down to the bank and we let rip at them. And we says, we have done absolutely nothing. It's not our obligation in terms of identifying the clients. You must come to us and say, in order for you to be able to comply with the Act, you need our proof of residence, ID, whatever it is, whatever you want, you can have, you're entitled to it. But you've never asked us for it. So it's you that are not complying with the Act. We can only comply when you tell us what you want from us. If we then don't give you that information, then we are not complying. Then you can freeze our account. But don't you dare freeze our account when it's you that have not complied with it. That gets down to they didn't understand their obligations in terms of the Act, and they wanted to put their obligations onto us. Another time, we have bank accounts that we only use for debit orders, and I had a debit order going through, and I was short of cash, and there was a debit order going through either that day or the next day. So I went into the bank and I deposited 300 rand in cash. And the teller says, can I have your phone number, please? Now, I give the minimum amount of information out to anybody at any point in time. So I said, no. I says, why do you need that? I says, I filled in the deposit slip. I says, it's got the account name, it's got the account number. I've signed it. You can look on your system and see it's all right. And I'm depositing 300 rand. And she says, no, but we need it. I said, but why do you need it? She says, no, she needs it in terms of the FICA Act. I says, no, you don't. You see there, cash transactions above certain limits. 300 rand is not above the certain limit. What is the point of the FICA Act? Money laundering, and only money laundering. That's it. There may be other hidden reasons, but the public reason is money laundering. I am depositing 300 rand, so my debit order doesn't bounce. That is not money laundering. You don't need to know it in terms of FICA, and no, you may not have my cell phone number. And then I felt sorry for her, so I just gave her a fictitious number, and she knew it was fictitious as well. And then the next story with regards to FICA, which I'm going to tell you about, and I'm actually going to name the people because we actually have a good relationship with them, is many of you will know that we've got the Gender Mainstreaming Awards coming up on the 6th of October at Gallagher Convention Centre. Well, we've entered into the contract with Gallagher, and they were really superb in negotiating the contract because there was a lot of to and froing with them. But the one bit that we didn't agree with them on was that they says that in terms of FICA, we had to give them certain documentation. And we said, no, we don't. And I says, the reason that we don't is why? Because you are not an accountable institution. Here's Schedule 1, here's all of the accountable institutions, and you're not there. So you are not an accountable institution, therefore we do not have a business relationship, therefore the FICA Act does not apply to any business that we may or may not be doing, so no, you can't have our document. They sent it off for legal opinion. The legal opinion came back and it was shocking, absolutely shocking. And they were saying, yeah, but yeah, it's right. You are not an accountable institution, but everybody's got a duty in terms of money laundering. And if you don't get the documents, well, how are you going to be able to deal with that? No, yeah. First of all, you have to have a suspicion that we are money laundering. So please tell us you got that suspicion. And if you have got that suspicion, how's our documents going to help you? Yeah. The gutters would have been registered at CIPIC. So if you give you those documents, how's that going to help you? It's not going to help you at all. So yes, it is no. But FICA, there's 6 things that you need to know. Anything else is somebody else's baby. Cole, next one.
Okay, just give me a second.
Yeah, go in, go out.
Okay.
Okay, we mentioned just now, we spoke about the Consumer Protection Act. Okay, Consumer Protection, it's 94 pages long, it's 222 clauses. Interpretation and purpose, 7 clauses. The main body is 74 clauses, which is 61% of the actual act. Commission enforcement is a third of it. So straight away, I will not read a third of the act. The body is 61%. So let's say it's 2/3 of the act. But again, will I read the main body, or sorry, all of the main body? No, I won't, because there's certain things in there with regards to, I don't know, direct marketing or whatever it is. I don't get bothered with direct marketing these days, and I'm not a direct marketer. So that whatever sections on direct marketing, I won't look at. I'll just go skip straight through it. Again, going through the index. So let's say out of that 61%, I may read again 2/3 of that. So I may read 40% of that. So reading that act, I'm reading 40% of the act, and that is all. Well, next one. Okay, National Credit Act, we had to look at that. Interpretation and purpose, 4%. The main body, that's now 50%. The regulatory enforcement, no. Tribunal, no. Registration, all I need to know is that a credit provider must be registered. So if I want credit and I go to a credit provider, I will just look for his registration number to make sure that he's registered. That's it. Again, main body. Yeah, I will certainly glance through all of it. I will read again, maybe 2/3 of it. Credit bureaus, well, I don't care about credit bureaus at this moment in time. You might want to say, well, okay, I have had a bit of hardship in the last couple of years, and I want to see this. What are they entitled to do, this, that, and the other? You may read that. I particularly won't, but I may read another area. So again, I'll read some of that. Next one. Okay, now we're getting it onto the business side of it, the professional side of it, as opposed to the personal side. And the principles are exactly the same. Is that if it's something that you deal with or have some kind of interest in, again, the Labour Relations Act. I mean, yes, it's a big document. It's 222 pages. It's huge. 214 clauses. Interpretation, main body 55%, and I can guarantee you I would not read all of that. The commission and the resolution 18%, the Labour Court 15%. So unless I had issues that I was dealing with that involved going to the Labour Court or going through that process, then I would read those. Otherwise, it's a case of, well, what does it say? What does it not say? Your basic conditions of employment act, your occupational health and safeguard, all of those. Yes, but I will look at only the things that are relevant. Your basic conditions of employment act. What does it say about sick leave? When do you need, if you're an employee, when do you need to give a sick leave, a sick note? And the answer is, if you're off for 1 day, no, you don't. I think it's after 3 days you need to give a sick note. But if you're only off for 1 day, there's no requirement for you to give a sick note. Does your employment contract, is your contract in line with the Act? Yes or no. It's very easy to have a look. A lot of the time it's not. People employers put onerous conditions in their contract that are not valid in terms of the basic conditions of Employment Act. Again, a number of years ago, we let our domestic worker go, and it was actually during lockdown, and she'd been with us for a long time. So we says, look, we're going to be more than fair with you. And we were, and even though we bent over backwards and we paid her a lot more than we should have done, or we offered her a lot more than we should have done, she took us to the CCMA, and the CCMA came back to us, and we got, they basically says, look, they've got no interest in it at all, because we said what we had done, but they did point out that we had made an error in calculating what she was legally entitled to. And the CCMA pointed it out to us. I went back and read the Basic Conditions of Employment Act, and I was happy that they were correct. And I said to them, "There's no argument. It clearly says that we had to add another month's salary onto what she was due, and we agreed and we paid it." I'd actually read it wrong. And when they pointed out to and said, no, it's actually, this is what it says, I said, well, that's fine, that's why we'll do it. So again, Labour Relations Act, we'll read hardly any of this. Next one. Okay, we spoke about the Poppy Act. Yeah, again, purpose, yeah, the main body is 40%, the regulator 14%. Won't look at the regulator. All I need to know is that the regulator's there. If the regulator comes to me and says there's been a complaint, well, then I'll look at it. Enforcement and penalties, won't look at it. So you can see just with the ones that we're showing you here, they all have a very, very similar format, and it doesn't matter which act you want to look at or why. You just look at the index, you just go through it and say, those bits I'm going to read, those bits I'm going to go there. Next, I think this is the last, I think the next one's the last one. Okay, yeah, this is the last one. This is the Companies Act. Many years ago, I think it was Gerald Majola. I think he was named CEO of Cricket South Africa. No, he's the CEO of an organisation, and he turned around and says he's never read the Companies Act. That's why attorneys are there. He should be fired on the spot. You cannot be the CEO of any organisation and not know the Companies Act. Do you need to know everything? The answer is, of course, no. 197 pages, 225 clauses. Again, it's a big document. But what I was saying earlier, companies' names and incorporation. I've got a company, don't need to know that. The main body, if you're a director of a company and you haven't read the main body of the Companies Act, please fire yourself or go back and read it, because you, as a director, you have to know the main body. You have to know what your rights and responsibilities are as a director. Meetings, quorums, minutes of meetings. You have to know all of that. Winding up and business rescue. If you're not in trouble, you don't need to know about it. If you're the people that you deal with, if your clients are paying as they normally do and they don't have issues, you don't need to know about business rescue. If you're battling to get paid from a client, well, you may want to look at business rescue, because it could very well be that they are trading insolvently, which is illegal in terms of the Act, which you'll find in the main body. Public offerings. Well, unless you're going to list, then you don't need to look at it. And if you are going to list, you are going to have sponsors and advisors and attorneys and accountants who are going to do a lot of that stuff for you. So no remedies, there's an enforcement, no commissions, no admins, agencies, offences, whatever. No, won't look at it. But that's 38%, the main body. If you're a director of a company, I would read almost every single bit of that. There's very little bit of that I wouldn't read. But again, you go back to, you're reading 40% rather than the full amount. So, ladies and gentlemen, that's the last slide. That is how you read legislation that you want to know about, that you need to know about. You can find it everywhere. There's something about, do you need to take notes on a Friday and a Monday? There is something about a Friday and a public holiday, the day before a public holiday. You are correct. I'm sure there's something, sort of in there. Yeah, but again, as I said right at the beginning, don't take my word for it. If you are off sick and you want to know whether you need the a sick note or not, it's in the Basic Conditions of Employment Act. But you're right. I think if it's a Friday and a public holiday, I think that is an exception. But I'm just giving you an overview with a lot of the stuff that I've dealt with. I mean, especially things like the Criminal Procedures Act. Don't chance your luck and get arrested and then come and blame me if you get arrested, because I've given you a very, very high level summary of it. Yeah, I'll deal with it myself, but you would you'll need to satisfy yourself that that you know with what you're talking about. If you get it, let me tell you that at one stage I used to help people getting out of administration in terms of Section 74 of the Magistrates Court Act. I'm not an attorney. I've taken probably about 400 people out of administration. I've lost once. We were taken on review to the High Court. We won that one, as well. And in the court, if you get it wrong, they have to hear it on the merits of the case. So if you are technically wrong, you can go back and resubmit it. If the police officer arrests you, well, you're going to be in jail, and that's a bit more serious. You may not get a second chance. If you give the car over to a debt collector, you are not going to get a second chance. I remember I did one submission to get the person out of administration, and you have to give 10 days notice, and I'd given the attorney 10 days notice, but I hadn't given the court 10 days notice. I'd only given them the 1 day's notice, and the magistrate kicked it out. This is a magistrate in Germiston, hell of a nice guy. And I went in to see him, and I said, I'd just like to understand, why you threw the matter out. And he says, when did you give notice into court? I didn't even answer him. I said, thank you. I knew exactly what he was talking about. I hadn't given them the proper notice. I resubmitted it, given him proper notice, and he approved it. So that's that. Okay, so that is how you read legislation. Please, if it affects you, and I'm not trying to do attorneys out of work, and I'm not trying to say that all financial institutions are do things wrong in terms of repossessions and all the rest of it. All I'm saying is that you have a right. You've also got an obligation to you and your family to protect yourselves in the way that that you should do. Okay. Any questions?
No questions at all?
I don't believe I've gone deaf. Somebody must have questions.
That happened a long time ago.
I says deaf, not mad. There must be some questions after that.
No, nothing.
Everybody's going quiet.
No, that's fantastic. Okay, so if there are no other questions, thank you all for joining us this morning, and have the most amazing.
Sorry, Carl. Can I just say something? Because I know there's going to be questions afterwards on this, and I know that because there always is. You've got my email address. It's malcolm@businessengage.co.za. If you want a copy of this document, please just drop me a line. I'll send it to you with pleasure. If you've got other questions that is bugging you and on your head, drop me a line. If I can help, if I can reply to you, I certainly will.
Fantastic.
But
thanks.
Please go and lead.
Sorry, there's just some comments. It just says, thanks, Malcolm and Colleen. Thanks for a very informative session. At this moment, she has no questions, but we'll definitely reach out if anything pops into mind. What are credit providers doing to prevent fraudsters from getting credit on fraudulent identities?
Oh, that I wouldn't know. No, I wouldn't know that at all. But that goes back to why I say I will not give my information out to anybody for anything. Somebody phones me and they says they're from the bank. No, yeah, I'm not interested. I will not give any information out unless I'm absolutely compelled to. Even to the extent that we a number of years ago, as a company, as Business Engage, we were filling in vendor forms, and it was something to do with it probably to do with the GMA, and they wanted all our financial statements. And I said, why do you want our financial statements? They've got nothing to do with you. Yeah, so yeah, we're not going to give you the financial statements. No, we want to make sure that that you're a going concern. I said, but our audited financial statements are historical. Maybe at that point in time, maybe we were trading solvently and great. Now we may be bankrupt. Those documents aren't going to help you to know that we're a good going concern today. So no, you can't have them. Okay. Thank you all for listening. I enjoyed it. And we'll see you all again when we see you. Thank you, everybody.
Fantastic. Have a great day, everybody.
Thank you.
Thank you. Bye.
Thank you.